to another session of Technology by Performix. I'm Ken Umansky, your host, and today we'll explore more of the world of technology. My guest today is Vincent Allen, partner at Carstens, Allen and Gourley. Vincent brings hands-on technology expertise to the field of technology law. His background as an A&P technician and aircraft inspector, combined with his practical experience, such as the design of IoT home automation systems, gives him a deep understanding of mechanical and electrical systems and the software that is so prevalent in technology today. This unique skill set allows Vincent to deliver effective legal representation in intellectual property, aviation disputes, patent and trademark filings, and cutting-edge technology matters, including AI software applications, medical devices, telecommunications, and aviation propulsion systems. Recently, Vincent has focused on the legal and ethical issues surrounding AI, helping clients navigate the emerging challenges and risks of utilizing AI, as well as protecting clients' innovations. He began presenting on Gen AI-related legal topics in early 2023, and later launched the firm's AI Triage Center to provide the full gamut of legal services for clients' AI-related software needs. Vincent graduated from Mississippi State University magna cum laude with a BS degree in electrical engineering and a JD degree from Baylor Law School. He also has a FAA A&P aircraft technician's license and private pilot certification with instrument rating. Welcome, Vincent. Thanks for joining me today. You bring a really different perspective to the podcast than I normally do. I've not had a guest talk about AI from a legal standpoint. I know my audience is interested in this discussion, so let's get started. First, a lot of companies are jumping into AI. What are some of the legal risks around IP that they might not even realize that they're facing? AI is such a hot topic right now. I think people think that they have to have it in their companies, whether they know where to put it or not. And I don't think they think about the implication or ramifications of what that's going to mean to their IP. Really, that's a topic that I think everybody'd like to hear your opinion on.
Sure, yeah, and I think it is right for companies to be wanting to implement AI. I mean, it's a revolutionary technology. That's the reason I started doing presentations back in 2023. I was playing around with ChatGPT, and I knew at that time that this was going to be a game changer. And it doesn't show any signs of slowing down. The technology is rapidly advancing, but at the same time, because of that rapid advancement, companies can sometimes get into trouble, by not thinking about some of the legal risk issues that come into play with using AI. Now, when it comes to intellectual property, the one thing that is currently circulating through the courts right now is whether it is okay to train an AI model using copyrighted works without the permission of the various authors of those works. And the courts have yet to decide that issue. I think it's going to be many years out. I don't think there's any question that the copyrighted works are indeed being copied during training of those models. But what the question really is whether it's a fair use to use that data to train a model. And so multiple different groups and authors have sued companies like OpenAI for copyright infringement. But we don't know yet what the answer to that question is going to be. And, until we hear from the Supreme Court or Congress acts to implement some exception to the rule against copying copyrighted works that allows it to be used in the context of training AI, it's going to be a question mark. And so what does that mean for companies that are using AI? What it means is that you have a potential copyright infringement issue when you're using it, because you could very well be reproducing some of the materials that were used to train the models. I think for the most part, there's probably not a huge risk in infringement of using the output of Gen AI, because usually there's not verbatim copying of the works, or if there is, it's only a very small portion, and it combines it with, a number of other things. And so I think that risk is pretty small, that the authors have, preferred to go after, at least so far, the companies that are actually developing the AI models and trying to get them to license those materials in order to use them, with permission, as opposed to without permission. So that's one big issue. The next issue is, well, what about the work that I generated with OpenAI or any other large language model? Is that going to be protected by copyright? Well, the copyright offices say, I mean, it's currently saying no. If it's generated solely by a Gen AI model, then that is not sufficient input by a human to give rise to copyright protection. However, if you make some changes to it and put your own spin on it, or make enough creative modifications to the work, then you can get copyright protection that way.
But what happens if a company uses someone's likeness in an AI application?
Well, yes, I mean that's problematic too, because there's still the law against using somebody's likeness, right of publicity. So especially if you're using the likeness of a celebrity, or even the voice of a celebrity, to try to reproduce their voice or style, I think you run into the risk of a claim from that celebrity that you are infringing upon his right of publicity. And so you can't really do that under, the current law.
Have any of these cases reached the Supreme Court yet?
No, they haven't. In fact, they haven't even gone to trial yet. They're still, in the discovery phase. Many of them have gotten past, the motion to dismiss stage of the proceedings, but that just simply says, well, we're not going to dismiss the fair use defense because, there's factual allegation that, a jury is going to have to decide, or we're going to allow the parties to do more discovery before, we can make a determination on that. And you could see some summary judgment motions being filed before a jury trial, but we're still relatively early in the process of those cases.
Okay. Well, next question. There's a lot of buzz around using AI models trained on massive data sets. What are the legal pitfalls when it comes to where that data comes from?
Well, as I mentioned before, there's the issue of whether, you have permission from the copyright owners, so that the training issue can be a problem. We don't yet know what that how that's going to turn out. But there's also other issues, like privacy concerns. Using an individual's private information might be prohibited under the privacy laws for training models. Even if you have permission to use the data in a particular data set, you have to make sure that the agreement provides you with permission to use it the way you're going to use it. So if you're going to use it to train a model, you have to make sure that that agreement allows you to do that.
Okay. Can you give me an example of an interesting legal case regarding Gen AI that you've encountered so far?
Yeah, I mean, I think one of the cases that illustrates the issue that I brought up earlier about the Copyright Office not agreeing, that work generated by a large language model are copyrightable. In that case is the Jason Allen case. It's pending up in Denver. What happened there is Jason Allen, he created some artwork using Gen AI, and he used 624 different iterative prompts, and for each prompt he had several outputs that he chose from, and then he continued to iterate and improve until he got to an image that looked like what he wanted, or what he envisioned in his mind. But the Copyright Office says, that's not enough. We'll give you copyright protection, but not in what was generated by the Midjourney tool that he used. So the output from that you need to disclaim, and we will give you protection on these modifications that he made. Well, what modifications were they? Well, he used Adobe, and he also used a gigapixel AI tool to improve the resolution of the image. So he used some of those tools, and the Copyright Office said, okay, we'll give you protection on those modifications, because if you look at the original work compared to the end product, there are some significant differences. So the Copyright Office said, okay, you can have protection in those, but not in the original work that was generated by Midjourney. And he said, well, I want protection on everything, not just, my changes, because, then somebody could take my original work and do their own modification to it and infringe my copyright. And so he filed suit in Denver District Court to appeal that decision by the Copyright Office. There's another suit called Patagonia, and Patagonia, they had a class action lawsuit filed against them. And basically they were using AI in their talk desk to help transcribe, process, and analyze customer conversations in order to determine the customer intent and the sentiment of that customer, and give feedback to the customer service rep while they were on the phone to them. The problem, though, was that the only notice that they gave was this call may be recorded for quality assurance purposes. And so the class action suit alleges that wasn't sufficient notice, and therefore you invaded our privacy under the California Invasion of Privacy Act. And so there's a class action pending on that. So that's just an example of some of the risks that a company might face. When they're using AI, you want to make sure you have someone who's helping you to provide the proper notices to consumers on how you're using their information, so that you can avoid that issue altogether.
So how can companies protect themselves when they're doing some AI work? With the current laws the way they are, how do they protect themselves? And what advice would you give my audience in terms of moving forward? It sounds like it's a slippery slope.
It definitely is a slippery slope, but again, AI is a great tool. It makes it easier. It makes it easier for companies to generate materials that they may need for marketing, for other purposes, and so you have to make a judgment decision on whether you need copyright protection on that work that's being generated. But my recommendation is, even if you are using a large language model or other AI model to generate these works, that you put your own creativity into it. You need to probably modify it anyway to make it fit with what you're doing, and to fit your brand voice, for example, if you're using it for marketing. So if you make tweaks to it, you can still claim copyright protection in the works that are generated. But I think you have to be careful if it's something really important and, you know, you don't want people copying it. Maybe you want to write that or create that from scratch as opposed to using OpenAI.
Yeah. Yeah, but it's so tempting to use OpenAI because it's so simple to use. And
That's right. Yeah. Well, I mean, another way to use it is just sort of a, you know, in the initial process of developing, you know, what you're going to do. You can always get ideas from these tools
right.
that you can then use to create your own work. So you can still use it in a manner that will help you be more efficient while still being able to maintain your copyright protection. And by the way, I don't agree that the Copyright Office is correct in the way that they are dealing with this copyright issue, because how is using a large language model any different than picking up a camera and shooting a picture? You know, you didn't actually mechanically, physically create that picture. The camera did, and we had the same issue with the camera back in the late 1800s, where the courts were faced with the same question. You know, can you get copyright protection in a photograph? And of course, the artists at the time were vehemently opposed to it because they were afraid that it was going to take away their livelihood, right?
Yeah.
And I think you have, you know, creatives even now who are, you know, concerned about these tools taking away their livelihood. And I think rightly so, they need to be concerned about it. But the people who are going to survive are the ones that learn how to use it, in my opinion.
So how did the Motion Picture Union, how did they solve the problem? Because that was a big issue in their renegotiation of their contract with the SAG contract.
Well, yeah, so they have it in their contracts, you know, that, you know, essentially prohibiting the use of OpenAI or, you know, other tools. And so that was so they're kind of trying to protect their artists that way. Whether that, you know, remains the way it is, we don't know. I think you're still going to have, you know, people wanting to use AI to create works, to write scripts, to, you know, even produce portions of the movie that may be used in a film, for example. So I think it's definitely going to be used.
Okay. Well, listen, we're out of time, unfortunately, because I could talk about this subject for a lot longer. But it sounds like AI and what's going on in the AI world is the Wild West yet. But thank you for giving my audience an understanding of some of the legal pitfalls to be aware of as they start to implement AI in their companies. How can our listeners get in contact with you if they want a question, if they have any questions of you?
Sure. My telephone number is 972-367-2001. And you can also reach me on my email, Allen, ALLEN, at CAGLAW, CAGLAW.com.
Vincent, thank you very much. And to my audience, don't miss the next episode of TechKNOWlogy, when we'll discuss how cutting-edge technology is being implemented across many industries and the results it's having with these companies. Remember to please contact Performance Business Solutions at performixbiz.com if you need help with any technology challenge, large or small. I'm your host, Ken Umansky, and until we meet again on another technology podcast, keep innovating.